o'clock, Mr. Sammith will be starting the session.
Yep, I'm ready. No problem.
Good evening, Sammith.
Good evening, sir. How are you?
Fine, how are you?
Good, sir. Doing well.
Thank you. All the best.
Thank you so much, sir.
Good evening. A warm welcome to all of you to the webinar series hosted by Advocates Association, Bengaluru. We have with us today Mr. Sammith S. Advocate, High Court of Karnataka. Mr. Sammith, we are happy to have you with us. Welcome to the webinar.
Thank you.
With my pleasure. Now, I would like to introduce our today's speaker, Mr. Sammith. He is the founder of Sanctum Law, a law firm based in Bengaluru. He specializes in commercial, contractual, competition, technology, media and telecommunications, white-collar crimes, municipal and real estate laws, both litigation and non-litigation. He graduated from University Law College, Bengaluru with 2 gold medals for academic proficiency. He has completed his post-graduation in international business law with merit from London School of Economics and Political Science. Previously, an associate with India's magic firms Cyril Amarchand Mangaldas and A2B and Partners. Presently, Mr. Sammith represents most of South India's leading real estate players having presence in Bengaluru. As a litigation counsel, Mr. Sammith has presented and argued several constitutional, criminal, and commercial matters before the Honorable High Court of Karnataka, Delhi, and Madras, respectively. Mr. Sammith, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you.
Thank you so much, Trivikram. I'm very grateful to the Advocates Association for giving young advocates a platform to express their opinions on certain subjects where even very learned members of the bar, senior members of the bar, as well as distinguished jurists, as well as sitting honorable judges have also presented. I feel very humbled and honored to be presenting today. So today's topic is competition law. So as you are all aware, sitting down in Bangalore, practicing in High Court of Karnataka, our knowledge of competition law is perhaps very limited because competition law is mostly a Delhi-focused practice, but recently, as recent as February 2020, we had a very learned senior counsel, Mr. Gopal Subramaniam, come to the High Court of Karnataka to a packed courtroom and held forth for about 2 days in relation to a matter. I think every one of us got very curious as to what is competition law, what exactly is competition law doing, and why is it so important for our economy to have competition law? What exactly is competition law? To begin with the definition of competition law itself, competition law refers to a law which ensures that there is fair competition in the market. It is nothing but ensuring the regulation of what Adam Smith termed as the laissez-faire or the free market. Coming to origins of competition law, any history on competition law or any webinar or seminar on competition law is incomplete without knowing how competition law came into force. Is it an ancient law like common law? Is it a property sort of a law or anything of that sort? What happens in competition law is that it did not come into force very early in the early part of the century or anything. This came into being in India. I will just come back to it later, but the origins of competition law globally started in England, 15th century England, when in common law there was judge-made law which related to unfair contracts, which mostly dealt with shipping contracts and goods and services. But there was no set formulation of the law. But this entire competition law started in the US, and it was termed as antitrust law. Why is it termed as antitrust law? There is an interesting history behind this entire thing being formulated in the US as antitrust law. Firstly, in the US in the late 18th and 19th century, there was a huge industrialization activity, be it in railroads, in oil, in banking, etc. And thereafter, what happened insofar as the trusts were concerned is that there were corporate charters which prevented one particular company from holding stocks in another company. So the proponent of these trusts were created by one person called John D. Rockefeller, one of America's biggest industrialists. He created the entire concept of trust. What did a trust do? These trust essentially was created as a non-earning, non-income, profit-oriented sort of a trust, wherein it could purchase stock of multiple companies across various state borders in the US. John D. Rockefeller started with oil companies. He wanted to monopolize the oil sector, which was going on very steadily in the late 19th century. In about 1880s, what Rockefeller did was very interesting. He created the Standard Oil Trust. What Standard Oil Trust started doing was that it started investing into stocks of various companies. So each of these companies looked independent on the face of it. But when someone dug into it deeper, what happened was very interesting. They found out that the board of directors of the trust had started controlling the affairs, management, and the business decisions that were to be taken by each of these companies. So essentially, although the companies appeared independent, each one started to follow the diktats of the board of trust, the Standard Oil Trust. Similarly, JP Morgan or John Pierpont Morgan, he started the monopolization of General Electric and the railroads in US. In order to circumvent this entire thing, what happened? The first US Congressman, Sherman from Ohio, a legislator from Ohio, came into a very interesting concept. He said that any sort of arrangements between corporations to set prices to control markets is antithetic to the capitalist system of America. So what he started is to ensure free market. The Sherman Antitrust Act was first passed in the year 1890. It was one of the most extraordinary legislations. It was a path-breaking legislation that came into force. What did this entire Sherman Act did? It frowned upon monopolization of businesses, and it indulged in both civil as well as criminal penalties for any monopolistic activities, as well as for any issues relating to restraints of trade. Restraints of trade meaning any issues relating to price fixing or any issues pertaining to demand and supply controlling. All of these things were started to be, regulated. Thereafter, in 1914, because they found that the Sherman Act was not sufficient, they introduced something called as the Clayton Act. Clayton Act went one step ahead. It also added price discrimination to its list, exclusive dealings, tying arrangements, and started something called as merger control in order to ensure that the entire market situation was very fair, competitive, and mostly it was not lopsided in favor of any one single company. This laid the foundation of the competition law or antitrust law as we know today in the US. Thereafter came a very interesting concept in the UK, upon which our laws are also based. The UK started something called as the Monopolies and Restrictive Trade Practices Act in the aftermath of the World War II. After World War II had happened, there were a large amount of corporations which had accumulated a huge amount of power, both economically as well as market power. And what they started doing is they started controlling prices, and each of the common man of England started getting affected. So immediately, the UK government passed something called as the Monopolies and Restrictive Trade Practices legislation in 1948. And in that year, a lot of things had happened. The British had exited from many colonies across the world, most notably India. Their business control was declining, and there was a huge economic downturn happening in the UK. So there was a socialistic government sitting in the UK back then, and they introduced such a concept. Then how did it come to India? It came to India very late, about 20 years after the UK legislation was passed. It came to India in about 1969. As a lot of you may be aware, 1969 was the year when Indira Gandhi government started the first bank nationalization. A lot of banks were conglomerated and everything. And this monopolies and restrictive trade practices acted as a precursor to the 42nd Amendment, which put in the words, a socialist in the preamble of our constitution. So in order to move towards the socialistic policies of the country, what the Indira Gandhi government did was, it introduced the monopolies and restrictive trade practices. However, this act was very wide-ranging. It ensured that there was literally no restrictive trade practices. It combined a lot of consumer protection law as well as market protection law into one particular legislation, which was very strange. And thereafter, it just said the MRTP aimed at social justice, welfare state, prevention of economic power concentration, controlling monopolistic, unfair and restrictive trade practices. There was a wide definition of the Monopolies and Restrictive Trade Practices Act. It was a stringent draconian law. An MRTP commission was brought in. Only Indian companies started getting benefit of it. Multinational companies, every time they tried to come into India, give the benefit of lower prices to the consumer, it was blocked by the monopolies and restrictive trade practices. So in post-liberalized economy, post-1991, about 8 years, India perhaps did not have the most stable of governments. There was a lot of political and other turmoil going on in the country. In 1999, when there was a stable government at last, the then finance minister, Yashwant Sinha, created something called as the SVS Raghavan Committee. SVS Raghavan was the chairman of Bharat Heavy Electricals. So he led the committee to bring this monopolies and restrictive trade practices into a post-liberalized economy, how this would be made consistent in the dot-com bubble where multinational corporations were continuously investing into India. And also when multinational corporations started accumulating more and more economic power through various acquisitions and mergers and joint ventures here in India. So what happened thereafter is very interesting. After almost 2 years after being constituted in about 1999, in 2001, the Raghavan Committee gave its final report. It made wide-ranging changes into the entire MRTP Act and structure. It stated that the MRTP legislation itself is inconsistent with the post-liberalized economic India. Thereafter, in 2001, the late Finance Minister of India, Arun Jaitley, moved the Competition Bill. And in 2002, the Competition Act 2002 was enacted. Once the Competition Act was enacted, there were a lot of discussions and wide-ranging debates pertaining to be it the Commission's own constitution or the Commission's powers. There was a lot of ambiguity, and more than ambiguity, what there was that there was a lot of lawsuits that were filed, writ petitions were filed on service matters, and there was also a debate on whether there should be a judicial member itself who should head the commission, or whether there can be an economic service member or an IAS officer who can head the commission. A lot of debate went into separation of powers. In this background, one of the most important cases that came to the fore was Brahmdat versus Union of India. In 2003, Brahmdat filed a suit saying that the Competition Act itself and the constitution of the commission was antithetic to the separation of powers as laid down in both Sampath Kumar's case as well as L. Chandra Kumar's case. Those were the two major landmark cases back then which dealt with constitution of various tribunals and all quasi-judicial authorities. Whether the Competition Commission was a quasi-judicial authority or an administrative authority itself was put to question. In about 2005, this entire question was settled because the government said they were bringing in amendments to ensure that there would be separation of powers, the judicial member would be appointed by the Chief Justice of India, and that there would be consultation with the Chief Justice of India before appointing any chairperson. However, one thing that did not change is that the chairperson, whether the chairperson should be a judicial member or not. What happened is the act remains stagnant, and till date it remains stagnant and states that the chairperson may either be a judicial person or a person from any of the civil services or an eminent jurist with about 25 years of practice. This is what it states in the Competition Act. Having regard to all of this, finally about 7 years after the enactment of the Act, in about 2009, the Competition Commission was first established, the members were finally appointed, and thereafter the commission started functioning. But the entire thing about this, the history of Competition Act itself or the scheme of the Act is basis that there should be no adverse appreciable effect on competition in India. So if I can just go through the scheme of the Act, it presents certain interesting concepts. What does Competition Act? What is the scope of the Competition Act? What it prevents? And what are the penalties and liabilities under the Act? I'll just run through it briefly and not hold back a lot of time. So first thing is something called as anti-competitive agreements. What is an anti-competitive agreement? There are two types of agreements in anti-competitive agreements. One is that there is an agreement between players in the same level of the supply chain. For example, let me give you, a competitor to a company itself starts cartelizing with its competitor. For the biggest example I can give you is cement players. And Ambuja Cement would start cartelizing with ACC Cement and start fixing prices. So this is what is the horizontal arrangement. The next one is something called as a vertical arrangement or the vertical agreement. What happens in a vertical agreement situation is very simple. In a vertical agreement, there are players at different levels of the supply chain. There can be a player who is into manufacture of tires, and then there can be a person who is into manufacture of the rubber. So there is an agreement between them to prevent competition. Let us say there is a market dominant player on manufacturing rubber, and then there is a market dominant player on manufacturing tires. So what these two guys do is that they come together, they decide that, okay, you supply rubber only to me, or you supply rubber to me at this price and to everyone else at a different price. So such sort of arrangements or exclusive dealing or refusal to deal starts happening. That is also an anti-competitive agreement. And the next type of thing which is frowned upon by the competition law or the Competition Act is the concept of abuse of dominant position. So what is a dominant position in the market? There are two things to determine a dominant position. One is whether a company is dominant in a particular relevant product market as well as a relevant geographic market. A product market is a specific type of product. Geography may mean either a city as a whole, a country as a whole, or as a city as a whole. So this came into being. These are the two major aspects that the Competition Act frowns upon and ensures that there is enforcement and regulation in respect of these subjects. So in addition to all these, there is also individual liabilities, not just on companies and juristic persons, but also individual liabilities where the Competition Act lifts the corporate veil, goes and sees as to which persons are actually involved in these anti-competitive practices, and then goes against them under various clauses. So to start with this entire, in addition to all this, the regulation of Competition Act or the scheme of Competition Act also looks into something called as merger control or regulation of combinations. So there are various companies which come into India or which are already existing in India, which enter into various sort of agreements. They enter into share purchase agreements, they enter into mergers, they enter into joint ventures, they enter into acquisitions, acquiring smaller companies. But why is the merger control being also regulated? That is to ensure that there is no single company which creates a monopoly or acquires a dominant position by such acquisition in the market. Because there are powerful companies which, in order to prevent competition in the market, may go and acquire a smaller competitor or a smaller company in order to ensure that there is no competition in the market and there is a monopolistic behavior in the market. So these are the various types of regulating activity that is contemplated under the scheme of the Competition Act. So then comes the question of what are the notable cases, what has happened in the Competition Act, and what exactly Competition Act is doing today. So first, the very first case before the Competition Commission that came up was regarding the Cement Cartel. What happened in the Cement Cartel is that the Builders Association of India, a body of all the real estate developers which came together under the banner of Builders Association of India, complained against the Cement Manufacturers Association and about 11 other cement companies, most notably Ultratech Cement, or in its previous iteration, Birla, and then Ambuja Cements, ACC Cements, India Cement, Ramco, etc. So what was this entire complaint about? The complaint was that the cement manufacturers, being in an oligopolistic market, which means that there are hardly a limited number of players in the entire market, they control the entire market scenario. The cement market itself was being controlled by them. What they used to do is, they used to use the meetings of the Cement Manufacturers Association, which is the association of all the cement manufacturers. And then they started discussing prices and also limiting supply and production. That is what they used to discuss, is what was the allegation. The Competition Commission, then it was in its nascent stage. There were a lot of executive branch of the government which was involved in both investigation. The investigation is done through a separate wing called as the Director General of Investigation, which is a wing of the Competition Commission itself. They did an entire investigation. They found out some very interesting aspects. So the prices of every bag of cement used to go up marginally by each and every company. So let us say Ambuja has a cement bag for about 250 rupees. After a meeting of the Cement Manufacturers Association, Ambuja's price used to go up by 1 rupee. ACC Cement's price used to go up by 50 paisa. Ultratech Cement's price used to go up by 1 rupee 50 paisa. Lafarge Cement's price used to go up by 2 rupees. But in this entire range and bracket itself, what the cement manufacturers did was they started dictating prices. And this was found through the investigation that every time there was a meeting of the Cement Manufacturers Association, within a day or two, there was immediate increase or a slight dip in the cement bag prices. Thereafter, they also looked into something called the controlling of production and supply. What the cement manufacturers did in order to create an artificial scarcity in the market, the cement manufacturers started producing only about 50%, 60% of their actual capacity. The capacity utilization in each plant of these cement manufacturers was very interesting. They started producing, as opposed to 100 metric tons, they started producing, as opposed to 10 metric tons, they started producing about 3 metric tons, 4 metric tons. They created this entire scarcity in the market so that they could immediately raise prices and ensure that they have the control of the market. So this was found out. But the most interesting aspect is all this relates to economics. What is the legal thing that regulates competition law? What is the scope of judicial review? How competition law is also susceptible to certain legal aspects came to being in a very simplistic manner before the Competition Appellate Tribunal. What had happened is very interesting. While the final hearings of the cartel, alleged cartel were going on, the chairperson of the commission who was present at the last date of hearing did not present himself at the previous two final hearings. He absented himself, and thereafter he goes and signs the order, final order that was passed as against the cement producers. That order levied a penalty of almost mammoth proportions and something unheard of in the entire Indian landscape. About 6,137 crores was the total penalty levied upon 11 cement manufacturers. About 1,187 crores was the highest penalty levied upon one cement manufacturer, which was Ambuja Cements. And there were similar penalties depending upon the turnover of these cement companies for average turnover of cement companies for the preceding 3 years. So when a 6,000 odd crore penalty is levied by an economic regulator in the country starts immediately taking note of this. Then there is a huge judicial scrutiny as to what are the legalities of the order, what is the legitimacy of the order itself. And that is when the Competition Appellate Tribunal, which was a complete judicial body consisting of a judicial member as the chairperson, who was a former judge of the Supreme Court of India, as well as an economic member who was a retired member from the Indian Administrative Service or the Indian Revenue Service or Indian Economic Service. A bench of these division bench of the Competition Appellate Tribunal held that the Competition Commission, in its zealous attitude towards penalizing these cement manufacturers, forgot the basic notions of law, the basic principles of justice, which is that one who hears must decide. That aspect itself was forgotten. So what did the Competition Appellate Tribunal do? It remanded the case back to the CCI for a fresh adjudication. So all that the CCI had done from 2009 to 2012, 3 years of investigation came to a complete naught. A fresh investigation was done, fresh hearings happened, and in entirety, about 6,137 crores which were to be legally paid to the government by virtue of the penalty got stuck. because the Competition Commission failed in its duty to adhere to principles of law. The other notable case in the initial years of competition law was Competition Commission of India versus Steel Authority of India Limited, which went all the way to the Supreme Court. So what happened in this case was Jindal Steel brought a complaint as against Steel Authority of India Limited, which had a literal monopoly on rail tracks. So the Indian Railways had an exclusive contract with Steel Authority of India Limited to ensure that any steel that had to be supplied for rail tracks had to be supplied only from rail. So Jindal said that Steel Authority of India is abusing its dominance in the rail track market, and it is going to the extent of completely distorting competition in that market as a whole. So upon a consideration of that complaint, the Competition Commission passed something called as a prima facie order. What happens in the Competition Commission's investigation and how an adjudication is arrived at is found in the scheme of the Act. A complaint can be lodged in three methods. The first thing, by a private party or an aggrieved party. The second being by a department of the government or a statutory corporation. And the third thing being taking suo motu cognizance. These are the three methods in which a complaint can be instituted before the Competition Commission. Once a complaint is instituted, what happens is the Competition Commission will have to look into the complaint, see if a prima facie case is made out. And if it thinks that a prima facie case is made out, then under section 26 subsection 1 of the Competition Act, it passes an order to its Director General, which is the investigative wing, to conduct a detailed investigation into the alleged anti-competitive practice, whether it be abuse of dominance, or whether it is cartelization, or whether it is anti-competitive agreements in the form of vertical restraints. Any of these things, that an investigation has to be done. If the Competition Commission feels that there is no requirement for an investigation, then it can at the very threshold itself, it can proceed to dismiss the case. So what had happened in SAIL's case was very simple. The CCI passed a prima facie order directing the Director General to conduct an investigation. The appeal provision under the CCI, however, does not provide for an appeal from section 26 subsection 1, which means that there is no appeal as against a prima facie order. So SAIL preferred a direct appeal to the Supreme Court, and the Supreme Court, first to the Delhi High Court and then to the Supreme Court. So Supreme Court started looking at various issues in relation to the constitution of the tribunal, the powers of the tribunal, the powers of Competition Commission of India, and various other factors. One thing what the SAIL order set in stone was that it clarified to a great extent the judicial review that is available to a party for any orders of the Commission, whether there is an appellate remedy available for a prima facie order, what are the judicial safeguards that have to be implemented before passing such a prima facie order, and thereafter, what is most importantly, they took the view as to what is the wires of the section 26(1) order itself. The Supreme Court made some notable observations. The Supreme Court said that if a prima facie order has to be passed by the CCI, it is not necessary to give a notice to the opposite party, that is, the party against whom the complaint has been made. There is no requirement for a statutory notice to be given to the other party to be heard before an investigation order is to be passed. that discretion lies with the Competition Commission entirely. Then it states that, but however, if an order is passed without any reasoning, if a non-speaking order is passed, then such an order is amenable to judicial review. However, if a reasoned and a speaking order has been passed under section 26 subsection 1, then judicial review is impermissible, is what the Supreme Court said. It basically said that the entire section 26 subsection 1 proceedings, which is the initial prima facie opinion stage, is an administrative proceeding and not an inquisitorial proceeding. However, it gave discretion to the CCI to say, if you require the presence of the opposite party, you can always send a notice to them to have their presence before passing a 26(1) order. That was one thing that the Supreme Court greatly clarified, so that the entire judicial review or the amenability of any CCI order to judicial review under writ jurisdiction was clarified. And it also clarified on one other important thing. The CCI also has power to pass interim orders to stop any alleged abuse or any alleged cartelization. So what the Supreme Court said is, Section 33 order cannot be passed without application of mind, merely on an application by a complainant. What has to be done is that the CCI has to go into the entire aspect of market dominance in case of abuse of dominance or the alleged anti-competitive agreement. There should be a clear prima facie case, and thereafter there should also be an extraneous circumstance that if such an abuse or the illegality continues during the course of investigation, then such an illegality may completely distort the market and affect the end consumer. So it is only in rare circumstances can such an order be passed. This is something akin to Order 39, Rule 1 and 2 of the CPC, where injunctions are passed. Thereafter, the CCI's powers and the entire judicial aspect of the CCI started getting to be more serious. A judicial member who was a former judge of the High Court was to be appointed. An amendment was brought into it in the year 2011, so as to enable the CCI to start taking a legally reasoned orders, because the penalties were huge as well as enormous. So what did the CCI do? The CCI thereafter started following certain due process aspects in every order. The CCI started to record all its each and every proceedings which was never being recorded. And the CCI also started passing spoken and reasoned orders. That was the major change that happened. Then there is a very interesting aspect that came to the CCI. One of the most interesting cases that came to the CCI is the tire cartel case. So in the erstwhile MRTP Commission, there was an allegation by the Tire Dealers Federation of India saying that the tire manufacturers, under the umbrella of the All Tire Manufacturers Association, colluded, started fixing prices and also controlled demand and supply. This is very similar to the Cement Cartel. But however, one interesting aspect about all this is whether this entire MRTP case could be transferred to the Competition Commission itself. So Section 66 of the Competition Act provides the power of transfer. This power of transfer, however, is not unbridled and has its own safeguards as to when a case could have been transferred and whether a case could have been transferred at all. So what happened is the MRTP Commission had dismissed such a complaint by the Tire Dealers Federation. It said that the tire manufacturers were not engaged in any price fixing or any other arrangement. There was no anti-competitive arrangements. It was a perfectly competitive market. Thereafter, the same Tire Dealers Federation sent a complaint to the Ministry of Corporate Affairs. The Ministry of Corporate Affairs put a reference to the Competition Commission to conduct an investigation. Based on that reference, this was one of the first reference cases that came to the CCI. The CCI conducted a detailed investigation. They did not apply their minds while passing an order. They said that the Ministry of Corporate Affairs already has applied its mind before making the reference. And therefore, we believe that the reference of the ministry is right. And it passed an order of investigation. And then the investigation commenced. The investigation in this case was very interesting. What happened is, one of the tire manufacturers, MRF, went to the Madras High Court, said that our individuals are also being investigated. There is no allegation against the individuals in the complaint. It's not just the company being investigated. So the entire investigation deserves to be stayed. The Madras High Court said one thing, that under Section 48 of the Competition Act, there is a provision for such investigation. Individuals who are responsible for such anti-competitive activities can also be made liable. And thereafter, such individuals can be investigated. However, it said that because there was no specific averment or allegation in the complaint, or there was no investigation as against them, the CCI's investigation into, the CCI's decisioning or the show cause notice that was issued post the investigation to these particular individuals was incorrect and quashed those notices. This case is still pending because thereafter again the MRF approached the Madras High Court on certain other grounds of procedural irregularities, due to which the final order is kept in abeyance still now. One more interesting aspect of competition law is that it is not exactly legalistic in its approach. It also has various dimensions of economics, especially micro and macroeconomics coming into play at various stages. It is not a law per se, but it is something to deal with the regulation of markets in a legalistic manner. So economics is exactly the foundation of competition law. So what does this competition law, how is the interplay between various sectors? Let us say there are sectoral regulators. There is the Telecom and Regulatory Authority of India, the IPAB, which is the Intellectual Properties Board, and there are other sectoral regulators, Electricity Commission, etc., which are there. So one of these cases that came before the Delhi High Court was in a case of Ericsson, which was brought by Micromax and Intex. So Micromax and Intex were manufacturers of mobile handsets. They had certain requirements for something called as a standard essential patent, which means that the patent is required for the functioning of an entire market, and it is an essential or a prerequisite for a functioning in a market. Ericsson held a patent for wireless technologies, mobile transmission receivers. So what Ericsson allegedly used to do was that it started levying unreasonably higher charges of royalty on all these mobile manufacturers who started using those standard essential patents. Against this, Micromax and Intex, two mobile manufacturers, went before the CCI. CCI said, yes, this is a prima facie abuse. There is a clear abuse of dominance by Ericsson, who is a monopoly in this particular market of wireless transmitters and transducers. And therefore, an investigation requires to be caused. Against this order, Ericsson went before the Delhi High Court. The Delhi High Court laid down a remarkable judgment that came into force. What the Delhi High Court said was that just because there is also an aspect of another sectoral regulator which may overlap does not mean that the Competition Commission cannot investigate. The competition offenses are one side of the coin and the intellectual property offenses are other side. Infringement will be dealt with by the IPAB, whereas the issue of abuse of dominance is to be clearly dealt with by the Competition Commission itself. The Competition Commission has to investigate any activity which is deemed to be illegal under the Act, and this is a separate illegality or an abuse as opposed to an abuse of another law such as infringement. So the Delhi High Court made it very clear that judicial review is applicable only when the Competition Commission has no jurisdiction whatsoever. But in this case, it held that Competition Commission had jurisdiction to investigate as well as proceed to give a finding on any abuse of dominance within the perspective or the scheme of the Competition Act. This law has now been substantially expounded by, again, the Delhi High Court in Mahindra Mobility's case, which once again set out a broad interpretation of judicial review. It says that CCI cannot pass orders without jurisdiction. The CCI has to have jurisdiction in respect of the alleged offenses. It cannot pass any orders where it has no jurisdiction. This can be seen by the order of the Bombay High Court very recently in the case of Bharti Airtel and Star versus the Competition Commission. So what happened in Airtel's case was that there was the Telecom Regulatory Authority of India investigating into certain breaches of the TRAI Act by the telecom service providers. However, Competition Commission said that this also amounts to certain abuse of dominance and also certain anti-competitive agreement within the meaning of Section 3 of the Competition Act, and it proceeded to start an investigation. That investigation was itself quashed. So this starts, there are other methods of also anti-competitive agreements and other aspects that the Competition Commission looks into. One of the other aspects that the Competition Commission looks into is bid rigging, which is, very prevalent in government tenders or any government corporation PSU tenders. What happens in these tenders is a couple of major players in the sector come together. They discuss the prices amongst themselves. They start sharing markets. So let us say the government of Karnataka calls for a tender to supply cement at various locations during a particular year. So one supply may be to Bangalore, one supply to Bijapur, one supply to Mangalore, one supply to Belgaum. What happens is these manufacturers who have plants in Bangalore or nearby Bangalore, they give the lowest bidding LTP price insofar as the Bangalore supply is concerned, whereas the other manufacturers who have plants in various other locations start giving bids for the locations which are nearest to them. What happens is that each of these cement producers start quoting unreasonably high prices. They quote in a certain price band. Let us say that they quote between 300 and 303 rupees. Each of them quote between that particular price bracket itself. Then each of these cement manufacturers start sharing the market. This market sharing agreement was found out in Haryana, where the director of supplies and disposals, again, he also lodged a complaint with the Competition Commission of India as against 6 major cement producers. What they used to do is that they eliminated the entire competition by quoting a price which was high, but also at the same time, it it was just marginally lower than what a smaller cement manufacturer would offer. About 6 cement manufacturers, major cement manufacturers, say Ultratech Cement, Shree Cement, all of these guys came together under one simple bracket and started doing the price bid rigging. So in each of these bid rigging, how was it orchestrated is very interesting. What they used to do is, before a bid was to be submitted, one day or one night before the bid was to be submitted, the managers or the regional in charge of a particular cement brand used to call all the other cement guys and says, okay, I am setting the price for so-and-so. This for Rohtak, this is my price. For Gurgaon, you can take the market. You set the price. I will quote whatever price you are quoting for the Rohtak market. I will quote for Gurgaon, so that you get the order for Gurgaon while I get the order for Rohtak. This ensures that the government is the loser in the entire scenario, and it is public revenue which goes into loss. So this case also was found out, and in 2017, the complaint was lodged in 2012. After almost 5 years, the Competition Commission gave its judgment. Thereafter, insofar as the other aspects relating to competition law is concerned, there are newer aspects that are coming in. I think I have 10 minutes left, so I'll not take much of your time. So, what are the newer emerging trends that are coming in competition law? There are digital markets, Amazon, Flipkart, all these companies indulge in something called as predatory pricing. What is predatory pricing? They price the products to be so low that a competitor cannot sell its products at all, and thereafter the competitor loses its market. What Amazon used to do, allegedly do, is that Amazon tells its sellers on its platform, see, this is the price band which you can set for this particular product. You have to set it low so that everyone purchases it only from my site. So between Amazon and Flipkart, because of the price war, there may be Big Billion Days, there may be Amazon India's days, everything. These are the aspects which were investigated into by the Competition Commission, and an order for DG investigation was passed. However, the Honorable High Court of Karnataka now has stayed the matter. The 26(1) order itself has been stayed. I'll not go into whether the order is right or wrong, but the law as it stands today is still as good as the Competition Commission of India versus Steel Authority of India Limited judgment. A 26(1) order cannot be challenged or subjected to judicial review except in a case where there is no jurisdiction for the CCI to investigate. Amazon's plea was very simple before the High Court. What Amazon said was that the Enforcement Directorate was investigating into offenses of bringing in certain monies. There is already a pending investigation. Therefore, the Competition Commission does not have any jurisdiction to investigate into alleged predatory pricing. So, however, the Karnataka High Court has now taken a view. An interim order has been passed in that case, where it has been stated that the Competition Commission prima facie appears to have no jurisdiction, and therefore, where an investigation is already pending before the ED, it could not have directed an investigation into the alleged anti-competitive practices by Amazon and Flipkart. The matter also now, I believe, is the subject of a writ appeal and yet to come up for hearing. So that is something that we can all keenly watch. But in all these aspects, what we see is that in digital markets, everywhere there are so many aspects of, be it bid rigging, be it price controlling, be it demand and supply control, all these aspects are there. And this affects the economy as a whole. The economic situation of the country itself is decided by how the markets function. Adam Smith's laissez-faire or the free market concept would be only fruitful if all the companies, private companies and multinational corporations start adopting competitive practices where there is fairness in the market. The end consumer is benefited because of such competition. And lastly, there is also the incentive for new entrepreneurs to set up their base in all these markets. In order to ensure that multinational corporations do not foreclose the markets, competition law is very important. It's extraordinarily, it brings to the entire economic situation of the country, it brings a sense of semblance. And moreover, what competition law does is that it puts a fear into heart of many multinational corporations which come to India and think they can dominate businesses and also, monopolize markets. They know that there is a regulator watching them. They know that there are regulations, there are high penalties to the tune of thousands of crores of rupees that can be levied as against them. Individual liability is also taken into force. All of these aspects come into being. I believe that competition law is something which supplements our Companies Act and also any laws relating to the economic stability of this country. While there are certain shortcomings and the commission happens to still be a quasi-judicial commission, there is enough and more methods for judicial review, appellate review. There is also scope for a detailed investigation to be made. And in all these investigations, there is a lot of fairness where Director General allows the presence of advocates to represent parties during the investigation, which was never there during the MRTP Commission. And in the MRTP Commission, only during the latter stages were advocates being allowed to even represent parties. So in Competition Commission, I believe that an effort has been made by the government starting from 2002 till date to ensure that there is fairness and equity all throughout economic markets, and there is competition so that all the end consumers are benefited every time. So I think I've covered an overview, bird's eye view, and I've not gone into much detailed aspects of it. I've also more or less covered what are the emerging trends in the competition law sector. I will now leave it to Trivikram to, proceed with anything else. Thank you, Trivikram.
Mr. Sammith, for a very informative. Can we now move on to the Q&A section?
Sorry, Trivikram, I'm unable to hear you. Your voice is very faint.
Am I audible now?
Yeah, you're audible now. Thanks.
Thank you, Mr. Sammith, for a very informative presentation. Can we now move on to the Q&A session? Am I audible, Mr. Sammith?
Yeah. We can certainly move on to the question and answers. Would be happy to answer them.
The first question, please.
Yeah.
Can we have the first question, please?
Please go ahead.
No, I am asking the audience. So, all right, we'll take up one offline question. So Naveen has 3 folded questions. Are the benches of CCI in other states? So it would be a one-word answer, so quickly.
I am looking at the question right now. So there are 3 questions. Whether there are benches of the CCI in other states. At present, there is no other benches. When the Competition Act was initially conceived, there were supposed to be regional benches of the CCI. Now, in accordance with the Tribunalization Act, I believe that the government is taking effective steps towards regionalization of all these benches, like how a National Company Law Appellate Tribunal has been now set up in Madras. I believe that there are efforts being made also to set up benches of CCI in every region, perhaps east, west, north, south is what I believe is happening. There is a movement towards this effect, but nothing has yet materialized. As of now, the Competition Commission stays only in Delhi. And the scope of practice for lawyers in Karnataka is a very interesting question. There are a lot of digital giants in Karnataka. IT giants are in Karnataka. Digital markets, all of them, Flipkart, Amazon, have all their registered offices based in Karnataka. And so many other digital giants, Infosys, Wipro, all of them have their entire registered offices in Karnataka. There may be complaints as against them. There may be possible cases of, violating provisions of the Competition Act. While I agree that, the scope compared to vis-a-vis for a Delhi lawyer as compared to a Karnataka lawyer is limited, I will certainly say that there is certainly some scope, and a lot of jurisprudence on competition law has to be still expounded. A lot of jurisprudence is not by the Supreme Court, but rather by the Delhi High Court. I think there is a lot of scope for companies based in Karnataka to approach, the Honorable High Court of Karnataka, and there are so many aspects of CCI which requires review, both the act itself as well as the actions of the CCI. So I think it is certainly going to be an emerging practice in the years to come. Can a complaint be filed against foreign companies doing business in India is the next question. Yes. The answer is certainly yes. And one of the major differences between the MRTP Commission as well as the Competition Commission is that MRTP Commission was very domestic in nature. The Competition Commission, on the other hand, also has extraterritorial jurisdiction. What happened in a very interesting case is, for a car to be manufactured, there are multiple parts that go into it. Be it seatbelt sensors, be it AC walls, be it silencer pipes, or the mechanism or engine walls. All these things are there. So there were a lot of these Japanese companies which used to supply to automobile manufacturers. What they did is, they used to discuss prices, everything sitting in a sushi restaurant in Japan. So in a sushi restaurant in Japan, what they used to do is, there is a concept of rolling sushis, and every time on the travelator, the sushi rolls up. They used to stop at a particular point and discuss, okay, this is where we go into a crowded sushi restaurant. They used to discuss prices. Then the price was communicated by separate individuals of different companies to their counterparts in India. And thereafter, the prices were set in India. Whenever the automobile manufacturers started calling for tenders, or they started RFPs for various spare parts, these Japanese manufacturers used to completely give high quotes by cartelizing sitting in Japan. So that was also there are about, I believe, more than 60 to 90 cases against Japanese manufacturers of various spare parts. And in one or two cases, the Competition Commission has also already arrived at a decision and penalized them. So that is also one aspect of extraterritorial jurisdiction of the Competition Act. And the other difference between MRTP and Competition Act is that, there's a next question, is that MRTP was very limited in its scope. It frowned only upon monopolies and unfair contracts. Unfair contracts can be even in the nature of consumer contract, and it need not be a dominant supply. So the Consumer Protection Act of 2009 describes unfair contract to a great extent. And even the 86 Act also, there were clauses of unfair contract. there were overlaps between MRTP as well as the erstwhile consumer forums, and therefore it resulted in a lot of clash. Competition Act to a great extent gave clarity insofar as these two are concerned.
So my personal question is, in terms of the cartel, so what is your view? Because most of the, for an example, if we take up Airtel and Vodafone or any of the other players in the market, most of the time it looks like, the difference of the prices would be very less. So it looks like more or less it is a cartel which is against the intent of the legislature. So would you like to throw some light on the cartel?
Yeah. Thanks, Vikram, for your question. I think it's a very interesting question. So what happens in these markets? Sometimes markets require equalization of prices in order for companies to sustain. There may be unconscious price parallelism. So what you essentially stated is something called as price parallelism in economics. That price parallelism may be there subconsciously in order to ensure that the market itself is competitive. In a matter of 5 paisa, 10 paisa, 50 paisa, these companies compete. And that makes a lot of difference. And that is how the consumers are attracted to it. It's certainly an oligopolistic market. And I believe that there is a lot of scope for, the market to correct itself. The market can correct itself. It's not a cartel exactly, but it is a case of, the market reacting to the needs of the consumers, and which is very helpful for the consumers. In India, the prices of data is perhaps the lowest in all the countries combined. That is what I was reading in a study the other day. I think it's good for the consumer, but however, when Jio came in, all these players jointly sat together and said that for Jio, there should be interconnection charges. Jio phones used to get disconnected, and Jio went against these all the other major service providers, and it lodged a complaint before the commission, and then TRAI took cognizance. And this is the case which I stated, where TRAI had jurisdiction, because the Telecom Regulatory Authority of India has jurisdiction over all such things. The Competition Commission could not exercise its possible jurisdiction, and that is why the Bombay High Court quashed the investigation as against these players.
Thank you, Mr. Sammith. Can we have online questions, please? I repeat, can we have any online questions before we wind up today's session? Looks like no more questions. That's about it. Mr. Sammith, I would like to extend my many thanks to you on behalf of Advocates Association Bengaluru for today's presentation. Thank you so much.
Thank you very much. I'm very grateful for the opportunity that the Advocates Association is giving to even young lawyers, and I would like to reiterate my gratitude to all the well-wishing members of the bar, who have patiently listened to me over the past 1 hour or so. I hope that if I made any mistake, please correct me, and with your well wishes that we will further progress. Thank you so much.
Thank you. With this, we'll be signing off today's webinar. Thank you so much.